afternoon, everyone. If you please bring out the defendant. All right, Mr. Bowman, just have a seat. Okay, we're on the record. I'm Judge Stokes, and we are here for the State of Georgia versus Taekwon Terrell Bowman, SPCR 2301716 J6. Jonah Pine is here for Mr. Bowman. Christian Stolf and Catherine Bird are present for the state. Okay, so we're here for the bond hearing in this matter. I'll begin, of course, with, well, I'd like to hear from the state, but it's actually the defense's motion.
If the court would like to hear from the state, I can defer and let them start. Your Honor, it's the defense's motion. We'd ask to go after.
Okay. Mr. Pine.
Thank you, Your Honor. We're here today on behalf of Taekwon Bowman, also known as Quando Rondo. Already in the process of filing for a bond petition and emails that have been exchanged, there was some concern and talk about, well, Mr. Bowman is a celebrity. We want to make sure that everybody gets equal treatment, and with that being the case, we're going to just track the code section 1761, and address each of the bond issues as the statute lays them out. So, first issue under 1761C is whether or not my client represents a flight risk. The state would have to agree that he has 2 local residences. Those residences were searched. I'm not going to put addresses on the record for obvious reasons.
Sure.
But my client was born in Savannah. He was raised in Savannah. His grandmother, his mother, his father, his aunties, the mother of his child, his girlfriend, his daughter, they're all here in Savannah. If you're here on behalf of Quando Rondo, family or friends, please stand. Thank you, y'all. Good to see you. So, Judge, part of the question is what are his ties to the community? My client is like a local hero. Born and raised here, done good, had a successful business. And what's more, when it comes to the flight risk issue, within days of confirming that there was a warrant issued, my client turned himself into the Chatham County Detention Center. I had a conversation with Mr. Stolf on Thursday to confirm that there was a warrant. A day later, at 11:30, we're at the Chatham County Detention Center. There is no better evidence that my client doesn't pose a flight risk. He walked right into the lion's den. Nobody forced him. He did it voluntarily, Judge. We would submit there is absolutely no issue here of his being a flight risk. Second issue is whether or not he is a significant threat or danger to any person, community, or property. We, of course, are going to submit that there's no evidence of him posing a threat to anybody. Now, we've got an indictment that he is seeking the bond on. Obviously, that's an allegation. My client stands before the court innocent. And so by that standard, we can't look at this allegation in the indictment and say that, well, based on this, he's a risk. They haven't proven that. They've just alleged it, and the court knows how little evidence it takes for that to happen. There's a question as to whether or not, and this is the third prong of the bond issues, whether or not he is a significant risk of committing any felony while on trial. And it is in this regard that a person's prior record becomes relevant. My client has one prior felony conviction. It was based on an incident that took place in August of 2016. So almost 7 years ago, he had the only felony that he's ever been accused of up until this time. And that particular case was a theft by receiving. He entered a plea to that one felony count on November the 17th of 2017. Could have used first offenders and he didn't. We may seek to see if we can do it retroactively. But in the meantime, that is the only felony conviction that he has, and I'm going to point out, it's a theft by receiving. Standard for that crime is that he had a gun that he should have known was stolen. That's it. Based on that, I don't think anybody can submit that he's obviously a significant risk of committing a felony pending trial. Finally, there's a question as to whether or not he is at risk of intimidating witnesses or obstructing justice. Certainly, there's no evidence that that's ever happened in the past in any shape or form. Part of this allegation in the new indictment is that he's a gang leader, and as a gang leader, he can intimidate and threaten people, I suppose they could try and say. I'll point out again, he's innocent unless he's been proven guilty. But if the state wants to use their allegation as a basis to try and argue that he is a danger or a threat, I'm going to ask that we take a close look at this indictment, what he is accused of here in this case. In the present indictment, Judge, we have a number of people who are accused. And who's listed as number one? Quando. It isn't because it's alphabetical order, because I'm looking at the list right now. I have a copy for the court, if the court would like to be able to look on as we're going through. I know it's in the record.
You're going to go through each case?
No, Judge. There are only 4 counts that apply to my client anyway, so we don't need to cover 49 counts.
I was about to pull it up, but you can hand me the copy that you have.
Thank you, Judge.
Thank you, Mr. Wade.
So here we have a 49-count conspiracy indictment. He's listed as number one. You would think that he would be all over this, but he isn't.
So before you go further, Mr. Pine,
Yes,
what are
Judge.
the 4 points you're going to make?
I'm pointing to the 4 counts that he's accused of as counts 1, 2, 3, and 4.
All right.
So starting with count 1. This is a conspiracy to violate the Georgia Controlled Substance Act. And the allegation here is that he conspired to distribute marijuana. We're not talking about a violent crime, but when they describe what the acts are that my client allegedly did towards the commission of this conspiracy, one of those is that he instructed somebody to negotiate marijuana prices for purchase, not for distribution. So even though it's a conspiracy to distribute, they're describing somebody trying to negotiate prices for a purchase.
And I understand, Mr. Pine. I think the gist of what you're explaining is that these are nonviolent crimes.
That is absolutely correct, Judge, but there's a bit more to it than that. And at any time, I'll shut up and move on if you need me to.
Move on.
Thank you. Everything in count 1 that's describing him, then again, is a purchase, not a distribution, an act towards a purchase. Count number 2, use of a communication facility, again, saying that it was to purchase marijuana. Count number 3, this is the crux of what we're dealing with. This is the street gang terrorism crime where he is alleged as being a leader of the Rolling 60s. Because that's the most significant, Judge, I'm going to circle right back to it. Count 4 is a conspiracy to violate the Controlled Substance Act. This is not distribution even. They're saying he conspired to buy hydrocodone. these are small potato offenses. This really all comes down to the gang violation. Now, Judge, that is count 3 of this 49-count indictment. When you take a look at this allegation, it winds up talking about how he issued directions, that these directives demonstrate that he's a gang leader, and they give you specific descriptions of what that was. The first one is that he directed people to keep guns out of any vehicle that he's in. Their criminal allegation is a statement of his legal status. He's not allowed to be in a car with a gun. And yet they're saying that by saying that, he's demonstrating that he's a gang leader. The next statement is he directed people to provide him with guns, which is a big contradictory. In one instance, he's saying, keep guns away from me, I can't have them near me. Next, they turn around, they say he's trying to get guns.
Mr. Pine,
Yes, Judge, I'm moving on.
how many more?
That's it. That's it as to the indictment, Judge.
All right.
So, we know that this gang allegation is the crux of what this case is about as far as the state conspiracy goes. And Judge, by any typical standard, given his record, given the nonviolent nature of these allegations, I think that the court would ordinarily, and I think just about any judge would be inclined to grant bond. But the state is going to wind up arguing for a high bond if a bond is granted.
Objection, Your Honor. Mr. Pine doesn't know what the state's going to be arguing, and I prefer him not to say what.
That's true.
Thank you.
Sure. They may also...
Don't state what you expect the state to say.
Sure, and they may also want to ask the court to consider a leg monitor.
Let the state present what the state is going to present.
That's fine.
And if you need to come back and make statements about what the state is presenting, I will allow you a brief opportunity to do that.
Thank you. But Judge, we're basically asking this court to grant an OR bond. That is a pretty extreme request. And in order for me to demonstrate why we think that's appropriate, I need to talk to you about what happened the last time the government accused my client of a gang terrorist violation.
We're not
I'm
going
going to object.
to.
There's nothing to do with the elements of the bond hearing that we're here for today. He's trying to pollute the pool.
Judge,
The objection is sustained.
I understand. Given that, Judge, I'm going to ask the court to take a look. Frankly, my first exhibit is all a record of his previous case. I already had it labeled as Exhibit A. That labeling, of course, won't be appropriate if we don't introduce it,
No.
but
No, there's no need for that to be introduced.
that's fine, Judge. At this point, then, I'd like to introduce a letter from his employer. I've already provided a copy to the state. It's my understanding they have no objection. I'd like to tender this letter.
It did.
Thank you.
And that is labeled.
Exhibit B.
Okay.
Your Honor, my client is a recording artist, an entertainer, signed to Atlantic Records. He has an incredible career. He is a rap star. And that doesn't just mean that he's working and that he's earning a living, that he's got a job. It also means that he has more than just the support of friends and family. He's got the support of one of the greatest record labels that this country has, the same record label as Led Zeppelin and Ray Charles. That's his record label. So they provided a letter to us. I would ask the court to take a moment to review that letter, if the court would be willing to look at it. It is a very heartfelt letter. It talks about his career. It talks about the opportunities that he has. It talks about what kind of resources are available.
Your Honor, he submitted the letter. If you'd like to read the letter.
Sustained. I
Thank you.
have the letter and I will review the letter.
Thank you. Finally, Judge, we've got, and I've already provided a copy of this to Mr. Stolf. This is an itinerary. It demonstrates the events that my client has scheduled. Should the state request monitoring, I'm going to submit that monitoring with this kind of a profession is not really going to be very much of an option.
If you would like to go ahead and present that exhibit, Mr. Stolf, do you have any objection to this exhibit?
No objection, Your Honor.
And
And I've been
this is-
provided a copy.
Okay, thank you. It is admitted.
As the court can see from that exhibit, Your Honor, my client has a very busy schedule. But then again, it's not at all unusual in the music profession that nothing ever stays on schedule the way that you want it to. Flights get delayed, connections get missed, sound checks go wrong, events get changed constantly. There is absolutely no way that we can truly use a monitor to keep track of anything, nor do we have any real
You're arguing something that hasn't even been presented yet.
Your Honor, if they can tailor the argument to the point of a bond consideration, not what he thinks I'm going to argue.
Sustained.
Thank you.
Okay, Your Honor, at that point, then I'll close. Once they make their argument, if I need to rebut it, I'll request that.
I'll give you an opportunity to do that.
Thank you, Judge.
I am so sorry to the defense, but everything they thought I was going to say, I'm not going to say. So unfortunately, they just wasted a whole bunch of time.
Okay, so let's do this. You don't say what the defense has said or will present, and the defense will not do that either.
Well, the state is not asking for an ankle monitor.
Okay?
The state is asking that you deny bond. Let's go over the risks, because that is what we're here for, the risks. We're going to talk about flight risk. Mr. Pine said local hero. He's a local hero. He might be an artist, but he's also a gang member. He's also a narcotics trafficker. He brings in marijuana. We know that.
Objection, Your Honor. I'm going to object to the statement that he's a drug trafficker. That's not even an allegation.
He distributes narcotics.
Sustained. Be careful how you characterize. There has been an indictment returned. The indictment is not proof of anything. It states the allegations, and we are here to determine whether or not he's a risk to have a bond set.
Yes. And the defense is making the argument that he's a local hero, that he is not a flight risk. He is a flight risk, Your Honor. He's very good at multitasking. While being a performing artist with all these obligations, he's been able to be an active member in the gang, which has been alleged in the indictment. As alleged in the indictment, he's also been able to multitask and bring marijuana and hydrocodone into Chatham County. That's a fact. He said within days he turned himself in. On Thursday, he was notified, and I spoke with Mr. Pine, and he said it. He didn't turn himself in until Friday. The defense wants a pat on the back that he turned himself in. He had to. There was an active arrest warrant. So yes, he knew on Thursday morning that there was an arrest warrant for him. He turned himself in on Friday. So you don't get credit for doing the thing you're supposed to do. He's a flight risk because he has funds available to him. He travels regularly to Atlanta. He spent time in other parts of the country. We have where he's in Los Angeles and in different parts of the country. He is a flight risk to leave this area. Yes, there might be many people here who support him, but he has the ability to leave this jurisdiction. Is he a threat to the community and property? Yes, Your Honor. The calls that we have show that Mr. Bowman, while at a movie with his daughter, made a phone call to other gang members, other Rolling 60 gang members, and said, there are 1,100 members up here, 1,100 is the opposition, and said, bring your guns here. His words, Your Honor. That is a danger to the community. When you have people coming to a movie theater bringing guns.
Is that your understanding?
Yes, ma'am. That is the language that's in the indictment. When they say bring the guns, that's what he was saying. Bring guns to a movie theater because my opponents are here. That's a danger to the community, Your Honor.
And I do have that. I understand.
The next one, which the defense was mentioned, that he was saying, don't have guns in the car. That's true. He did say, don't have guns when you pick me up, because he's a convicted felon and he can't be in a car with guns. That doesn't mean that he still doesn't have people come with guns when he needs it to be. And again, that's been alleged in the accusation, in the indictment. He is a risk to the community. He is also a risk to influence witnesses. There are not 18 other co-defendants on this case. These are fellow gang members. Most of them, some haven't been charged with it, but a majority of them are fellow gang members. We have him as a leadership role. As leadership, he does have power and control under the individuals below him. He can influence them. He absolutely has the ability to speak with them and get them to change testimony, take responsibility. We have seen that time and time again in other cases. So yes, he's a risk to the community. He is a risk to the witnesses, of the intimidation of witnesses. the defense had a very laissez-faire argument about the gang. Oh, it's leadership. He just says contradicting things. The Rolling 60s are currently one of the largest and most violent street gangs in Savannah. That man is the leader of them. That is a danger to the community. We also heard the defense talk about he was buying weed. He was buying it. Yeah, he was. He was buying it from the plug, and they were buying massive amounts of it. Thousands and thousands and thousands of dollars. He wasn't buying personal use. This wasn't, I'm going to have fun this weekend. No. They were bringing in pounds of marijuana to Chatham County for distribution. So yes, you can't distribute marijuana until you purchase it. So yes, he was negotiating the prices of marijuana to then sell. We ask that you deny bond. He's a risk to the community, flight risk to intimidation of witnesses, and again, the charges stripped away from whatever Mr. Bowman does for a living. If we look at him as the leader of the Rolling 60s, which he is, and we look at the charges and the threat to the community with the guns, that alone is enough to keep him in. Thank you.
Thank you. Mr. Pine and Toadell will give you a brief opportunity.
Your Honor, everything that Mr. Stolf was talking about that presented what a risk my client posed for a bond is a part of the unproven allegations. I must state, they lofted a gang allegation against my client in 2019.
Objection, Your Honor.
It is not
Sustained.
irrelevant because
Sustained. We're going to stay away from that.
well, Judge, there is a credibility issue here. They're making
No,
an
Your Honor.
allegation.
Judge, everybody stop. We're not going to go back into that. So, Mrs. Dolph, you have a seat. Mr. Pine, you pick up.
Your Honor, I'm just going to submit that all the reasons that he gave you were all allegations that the state has the burden to prove, and they have not done it. Stands before this court innocent on those charges. They haven't presented evidence, they presented argument, and they have to talk about what they think they're going to be able to show later because they don't have anything from my client's past to demonstrate it. If we're going to treat Mr. Bowman like we treat everybody else, he gets out. He gets out on a reasonable bond. He is not going to require any monitor, in our opinion, nor would I think that monitoring is really going to be even effective in this kind of a situation. Given the circumstances and given the nature of these new charges, all of which are nonviolent, I'm going to ask the court to set a reasonable bond, and I'm going to ask that it be set as low as the court is willing to go.
All right, thank you very much. I am going to review the exhibits that you've presented. I'm going to review the arguments that both of you have made along with the indictment. I'm not going to rule now. I'm going to take it under advisement. All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, everybody.
Yeah, please. Thank you.
Yeah, make sure you're good.
Yeah.
Can't find my key. You make me nervous. Turn the phone because sometimes it sticks the other way. Yeah, thank you. Grab these microphones.